Hello, this is Jackie Jones, and this is Module 1 of a series of lectures in Week 2 in the Family Law component of Litigation and Estate Practice. This lecture is going to relate to applications generally and service of those applications. Just bear in mind that when I talk about service, it is, whilst it's pertaining to the family law arena, is a very important aspect of all litigation, and you need to be mindful of how you properly serve documents in any court hearing. Always check the rules. So in the family court we have numerous applications, and some of them are specific. So if a client is seeking to dissolve their marriage, to obtain a divorce order, then there is a specific application for a divorce. It is a standalone application. There is also an application that is a standalone, meaning it's not dependent on any other application, if parties are able to reach an agreement before commencing proceedings for a court determination. That application is an application for consent order. Again, it is a specific form, it requires detailed information, and this document is extensively used in practice. The initiating application is the one that gets you into the system. It starts the ball rolling, similar to the statement of claim you've been exposed to in the civil litigation module of this subject. And unlike a statement of claim, the family court arena refers to it as the initiating application. Now that gets the ball rolling, it starts the process, but if something happens after the filing of the initiating application and prior to the finalisation of the initiating application, it may be necessary for you to seek interim relief on behalf of your client. In the civil litigation aspect, you have been exposed to what's called a notice of motion. That notice of motion seeks interim relief on behalf of a party. In the family court jurisdiction, the form is called an application in a case. The application in a case sets out the orders that a party wants, and that application is supported by an affidavit, namely the evidence of the deponent, just like a notice of motion is supported by an affidavit. That is what is going to happen in your assessment task. The initiating application has already been filed, something has happened, and you are going to complete the application in a case document on behalf of your client. The purpose of any application is to give information about parties, and importantly to ground the jurisdiction of the court, to not only hear the matter but importantly to make orders. It is in fact importantly in the family court arena, the application assists in identifying to the other party what it is that everyone is seeking to achieve from the court process. Now, slide 5 deals with the standalone application for consent order that I referred to. As I said, this is extensively used in practice. It is a very detailed form requiring you as lawyers to go through and obtain information from the clients to be able to insert into the document. The reason why it is so detailed is that a registrar considers this application in chambers. There's no appearance by lawyers or the parties, and so what they have to work on, what they have to consider whether an order should be made in accordance with the agreement reached, is in fact the documentation that you and the other lawyer have prepared and submitted to the court. When I acted as a registrar of the court for a period of time, it was not uncommon that these applications were rejected, whether it was because the orders were not enforceable or the lawyers had not been able to establish the jurisdiction of the court to hear the matter, or that simply insufficient information was given to enable the registrar to consider whether, in financial matters, it was just and equitable to make a court order in accordance with the agreement of the parties, or if there was a parenting order to be made, whether it in fact was in the best interests of the child or the children that such order be made. So my tip for all of you as you start in this area is always obtain detailed information. Have a look at the document before you start preparing it. Make sure you've got all the financial detail that needs to be inserted into the form, and importantly, when you are drafting the agreement, or the consent order I should say, that reflects the agreement between the parties, you might want to include recitals, for example, which set out the information that the court can obtain a greater understanding of where are these parties? Have they been through a collaborative process? What was the contribution? Did someone's mother give them something? Is someone just about to receive an inheritance from a great aunt or an uncle? And that might all impact on why they've reached a certain agreement. But unless it's there, the registrar doesn't know about it, and if they don't know about it, it might on first blush of reading not fall within the just and equitable or best interests of the child scenario. So if there's been no agreement reached by the parties and it's then deemed necessary to file an application with the court, that application is the initiating application, and the first question to be determined is which court is it filed in, the Family Court or the Federal Circuit Court. Slide 7 gives you a snapshot of the various matters that the Chief Justice of the Family Court has determined are appropriate for the Family Court, and if it involves such matters, then that is the place for filing. Now, from the Family Court's point of view, if you have determined that it's an appropriate matter to file in the Family Court, you'll get an initiating application. You'll complete that application with the procedural information, details of the parties, and then you need to determine what orders you are seeking. First of all, are you going to be seeking only final orders, or will you be seeking final orders and interim orders? Now, if it is only final orders that you are seeking on behalf of your client in the initiating application, you will need to file a financial statement if those orders are only financial. You will need to file a Section 60I certificate if those orders include parenting, unless, of course, the matter falls within one of the exceptions under Section 60I, and that certificate the parties don't need to go to the compulsory mediation, and the certificate states that. If there are no interim orders sought, you do not need to file an affidavit. But if the initiating application does include both final orders and interim orders, then you need to have an affidavit as the evidence to support the interim orders that you are seeking. If that initiating application has been filed, and then sometime after the filing of that initiating application and before its determination, a matter arises that requires court judicial determination, then an application in a case will need to be filed seeking those interim orders. Now, if the interim orders sought, they will need to have an affidavit that grounds the evidence to support those orders. So an initiating application, just by way of summary, can include a final and interim order. You only need to file an affidavit if you are seeking an interim order. But after the filing of initiating application, I've certainly been involved in a matter where we had numerous interlocutory or interim applications after the filing of initiating application, and each one of those interim applications, which will be filed by an application in a case, each one must be accompanied by an affidavit. If there is an allegation that a child is at risk, then it is necessary to file the standard notice of risk form. Importantly, before any initiating application is filed in the court, it is necessary for parties to engage in pre-action procedures to see if they can resolve the matter. Have a look at Schedule 1 of the Family Law Rules, which talks about the disclosure of financial information to enable parties to have a real informed process of discussion about financial matters. From a parenting perspective, parties must attend the mandated mediation with a family dispute resolution practitioner unless it falls within one of the exceptions. Now, the Federal Circuit Court, if that is the one that you consider is appropriate to commence the application, it is essentially the same as the family court process, excepting in two important ways. Firstly, you must always file a notice of risk, regardless of whether there is an allegation or not. Secondly, the initiating application and the response to the initiating application must be accompanied by an affidavit by the parties. Now, this is to occur irrespective of whether there is an interim order sought or not. So it's part of the Federal Circuit Court rules that every initiating application and response to initiating application is supported by an affidavit. It's very important that when you draft an application, and particularly orders, and that's part of your assessment task, that the orders fall within the jurisdiction of the court. What does that mean? Does the court have the power to make those orders? Important for you to understand, you may need to look at the Act. So does the court have the power to make the orders? Importantly, are the orders enforceable? Now, there's some of the workshop material on the orders is specifically geared to that point, to get you thinking about how can an order be enforced. So what you're wanting to happen is that once an order is made, if someone doesn't comply with that order, you are able to go back to court and enforce that order. Make sure that something actually does happen. It might even be that you seek costs because someone has failed to comply with the order. But the whole purpose of seeking an order from the court is that it is actually enforceable. The applications do need to comply with the court rules. My tip for you is to have a checklist of information you require and to look at a blank application before you actually see the client. But there are rules and regulations as to what is required to be included in the application, just as there is to be included in an affidavit. So always check the court rules. And again, this is generic, it's not specific to the family law arena. There are different types of orders. Now, there are final orders that dispose of a matter. There are also interim orders. And those interim orders you might need to have pending further order. Now, what that means is that the order only continues until the court makes another order in respect of that subject matter. And that might be, for example, that it's pending order payment of a certain amount of money, for example. Or that something will only happen pending further order. There may be a changeover at McDonald's, for example, on a parenting issue, and that might be pending further order. So that's pending the court making a final decision as to where, or another decision as to where the changeover for the children should be. Sometimes interim orders need to be linked to a specific event by way of dates, for example. That assists with enforcement, so you would know that something has to be done by a certain date. Urgent and ex parte orders are certainly a feature in the family law jurisdiction. My experience in family law is that if it's urgent, it's usually very urgent and you need to act quickly, whether that be a parenting or a financial matter. In both urgent and ex parte applications, the court is going to be relying upon your affidavit evidence. I can't stress enough to you how important it is that the orders you seek in such applications are clear and concise, are specific, and that you have the evidence in the affidavit that supports that order being sought. If it is going to be ex parte, and that's obviously a very serious situation, ex parte means that the other side does not know that you are going to court. In those situations, your client will need to give an undertaking as to damages, and as I say, it's really only in the extreme situations that the court will consider an ex parte application. Courts do hear regularly contravention applications. Someone hasn't complied with an order of the court and a contravention application is filed. The court has numerous remedies available to it by way of the types of orders if a contravention is founded, and some of those are set out in on slide 15. There's also an application to appeal to the full court and or a stay of the application. Now, when you appeal to the full court, that actually doesn't operate as a stay from an order of the court. So in simple terms, the judge has heard the evidence, the judge makes orders. Those orders might be that the children live with the mother and see the father every week from Friday afternoon to Monday morning. The wife files an appeal from that decision saying that the judge erred, having regard to the evidence, and that alternate orders should be sought. Now, unless the wife seeks a stay of that order that the children live with the wife and spend time with the father every week from whatever the time period was I stated, will be enforceable unless it is stayed. So you might need to talk to a more experienced practitioner if you are in a situation where an appeal is lodged. Do you need to have a stay of the orders of the court that have been made? Now, slide 17 just talks about time limits in the family law arena. Sometimes it's necessary to file an application if time is about to expire. Otherwise, you might need leave, and I've just given you some details or give you some examples there of time periods after, for example, a divorce order is made or after relationships. Now, service is very important, how documents are given to others in the court process, and it's very important for you to research and establish what are the rules of service for a particular document, because the service of one application might be different to the service of other applications or documents such as subpoenas, applications, whatever it might be. If documents are not served correctly, there will be a delay, and I just give that as a flashing light that you go to the rules, make sure that you are well acquainted with how documents must be served in this particular area. Problems do exist with service, but inevitably it's because there's been a lack of attention to detail, that the lawyer hasn't gone to the Act and the rules and to work out what are the requirements. Process servers are used extensively, as in every other court process. Ask the process server where they're going to provide you with an affidavit, for example. Do they need to have a picture of the person that they are going to serve? There are instances where you need to make an application for substituted service, namely that you will serve somebody else rather than the person who is the other party to the proceeding. So a common one is the wife, for example, files an application for divorce. She can't find the husband. He has relocated, hasn't told her of his new address. He might have gone overseas, he might have gone somewhere else in Australia, and there's been no communication. But she knows where his family live, and she might contact, or her lawyer contacts the family to say, look, do you know where he is? Oh, look, we don't know where he is, but he does ring in, every so often. They do have contact with him, so it might be that you would file an application to seek an order that service be substituted on the mother or the father of the other person, because he can't be located. You do need to show the attempts that you've made to locate the person, and the social media now is a fantastic way of trying to locate people down Facebook, LinkedIn. There's lots of various ways to try and track people down. Texting is another way that you can at least engage with them to see if you can find out where they are. I've used text information with notifying about substituted service, for example. So sometimes you need to be a bit creative in the orders that you're seeking in an application if there is difficulty with service. If someone is overseas and there needs to be service with overseas, please check the rules. Don't just guess and think that it's going to be the same in relation to every court process. So another bit of a flashing light for you there. And importantly, it's all about attention to detail with service. Have a look at a notice of address for service. What is it? Has it been filed? Does it need to be filed? What information does it give? Why is it necessary? Why is the court looking for it? So have a look at that. As again, that's a standard form that gets filed with the court. If you are going to serve documents by post and are allowed to do so under the rules, make it easy for the person if you want documents returned back to you by giving them a self-stamped addressed envelope and post-it notes where you want them to sign and date, etc. And finally, it's not a standard form, but if there is a service time frame, so for example in a divorce you have to serve the other side with the divorce not less than 28 days prior to the hearing date if that person lives in Australia, and if they reside outside Australia you have to serve them not less than 42 days prior to the hearing date. Now you might get caught with those times, but the other side might be prepared to abridge that time and will sign a document saying that they haven't had the 28 or the 42 days, but they're happy for the time to be abridged and for the application to proceed. So that's something for you to have as a tool in your toolbox as well, and to use if necessary. And that's the end of this module of Week 2 lectures. Thank you.